Businesses tend to forget about copyright when they're thinking about intellectual property. A lot of them will focus on patents and trademarks, but copyrights tend to be left to the side. And that could be a big mistake for a number of companies. They figure they have their patents and what's the value. And I'll tell those clients that there's copyrighted expression all around their business. And I'll also ask those clients, how would you feel if another business copied your website or copied one of your advertisements? And so at that moment, those clients will say, yeah, well, they'd probably be upset and they want to stop that because it is one of their assets. And so you want to protect it to build up your assets as a company, to make it so that others can't steal from you, and that if your company is being valued, a copyright, just like any other intangible intellectual property, will just boost the value of the company. Getting a copyright is actually a relatively easy process. We'll put together an application for the client that includes an example of the copyrighted material, and we fill out the application, get the necessary, all the appropriate information from the client. And if it's a situation where an independent contractor had prepared up some of the information, like a website, we'll get from them any appropriate assignments if that hadn't already been done, and we'll file it off with the Copyright Office. Generally, then you will hear something anywhere from 3 to 9 months from the Copyright Office. Most of the time, it's a simple approval process. A lot of people assume that you don't have any rights until you actually get your registration, and that's not true. Your rights attach as soon as you create the original work of authorship. However, registering that copyright will give you tremendous advantages. First of all, if you register it within the first 3 months of publication, then any use that is an infringing use of it will entitle the original author to what's called statutory damages and attorney's fees. Statutory damages can be an automatic damage award of up to $150,000. One of the problems with suing someone for copyright infringement is actually proving how much damage you suffered because of their infringement. And so statutory damages give you an easy way. You don't have to show any actual damages. You just are awarded an amount up to the judge of anywhere from $750 to $150,000. In addition, as I said, you can get your attorney's fees, which is very unique in American jurisprudence. Most times when you're in litigation, it's each side will pay their own way. But with copyrights, Congress decided it was very important that copyright holders be awarded attorney's fees in case there's an infringement. And so as an advantage or an incentive to get people to register the copyrights, the courts will also give you your attorney's fees if you prevail in that litigation.